Hello, everybody. It gives me a great pleasure, not the least to be for the first time introducing here this audience and our esteemed colleague Jean d'Aspremont to provide us with this talk on international law as a belief system. So hopefully we are all believers, I suppose. So although there might not really be a need to introduce Jean, I'm still going to give it a try. Most recently, he has spent a couple of months with us, and we're very happy to have had you or to still have you here with us, and we're indebted for all those frequent occasions you participated both as a speaker and as part of our discussions for our research group. He holds a chair in public international law at the University of Manchester, where he's also founded the Manchester International Law Centre, together with his colleague Ian Scobie. He is member of the Scientific Advisory Board of the European Journal of International Law. He, before, used to be the editor-in-chief of the Leiden Journal of International Law, and so on and so forth. He appeared as counsel in the Kosovo advisory proceedings on behalf of Burundi. And prior to joining Manchester University, he was an associate professor of international law at the University of Amsterdam, having received his LLM from the University of Cambridge and a PhD from the Université de Louvain, où il a fait son doctorat de thèse, sa thèse de doctorat, l'État non démocratique en droit international. C'est vrai? Which has also been published in English afterwards, I suppose. Okay? So, Jean, you have the floor, and we're very much looking forward to having you here.
Thank you, Professor Zimmerman, for this way too generous introduction. I appreciate short introductions, and that was on the edge, but it's highly appreciated. I would like to actually seize this formal opportunity to express my gratitude to all the directors of the KFG research group for having invited me here in Berlin. I've spent 5 wonderful months, and I look forward to this 6th and unfortunately last month here. It's been a very enriching and immensely formative experience. I've also met very inspiring scholars with whom I hope to remain in contact in the years to come. I also want to pay tribute to the scholar after whom this lecture series is named. Well, believe it or not, almost 2 decades ago, Thomas Franck proved most instrumental, as you may have guessed, in the choice of my PhD topic, and I'm glad Andreas mentioned that here. This is how I came to write on non-democratic states and international law for almost a decade, before subsequently drifting into obscure debates on sources, responsibility, and the structure of legal argumentation. Although I have distanced myself from some of Franck's writing over the years, I believe I still share some of his ethos. Tom Franck, in my modest view, was always eager to provoke his peers into thinking and challenge shared assumptions, staying alert and being suspicious of what the field holds as fundamental without aversing into utter skepticism is maybe part of Franck's legacy. So it's my great honor, and it's with humility, that I will now deliver this new Thomas Franck lecture today at the Faculty of Law of Humboldt University. Ladies and gentlemen, dear friends and colleagues, my main claim tonight is that international law is a belief system. It is a belief system because it rests on some key fundamental doctrines which invent their own origin and dictate their own functioning. These fundamental doctrines of international law, and by that I refer to sources, statehood, responsibility, interpretation, personality, territory, and so on. Well, these fundamental doctrines explain their own formation and their own functioning. So the formation and functioning of these formal doctrines are regulated by the fundamental doctrines themselves. And the fact that these fundamental doctrines of international law explain themselves is, in my view, the mark of a belief system. I will substantiate that claim and proceed in 4 steps. I'll start with a few preliminary remarks and caveats with a view to delineating my claim. I shall then turn to a few conceptual observations on the notion of belief system. This is my conceptual framework. What do I mean by belief system? Thirdly, I will spell out the condition under which international law qualifies as a belief system, and what does it take for international law to work and function as a belief system. That will be my third set of remarks. And finally, I will share with you a few thoughts on what we gain from this exercise, what we gain from this image of international law as a belief system. So starting with my first set of observations, so just a few caveats, let me say that this is meant as a heuristic exercise. That means that I intend here to project an image of international law to make you appreciate things we constantly do without realizing them. Because they're so close, they're so ingrained in our argumentative practices that we have never apprehended them. So that's the purpose of this heuristic exercise, is to shed light on some and raise awareness on some underexplored dimension of our discourses. In saying this, I want to stress that this claim is not meant to be a grand descriptive claim about what international law is. So in other words, it's not meant to be a better view. It is not meant to be exclusive of alternative outlooks based on sources, based on rules, based on processes, and so on. No, I do not mean that my claim has any rational or empirical superiority. It is just meant as a heuristic exercise. The second introductory remark I would like to formulate, and the second caveat, is that making the claim that international law is a belief system is to take international law very seriously. Belief systems are very serious matters. So I want to make clear from the start that I'm not promoting here any kind of nihilism. I do not mean to invalidate the way we argue about international law and the way we construct our discourses. As I will allude to in my concluding remarks, I don't think that apostasy is an option. I do believe we are all meant to be believers. So the purpose of this exercise is not to repudiate current discourses and current argumentative practices. Of course, in saying this, I'm exposing myself to the criticism from one side of the spectrum of international lawyers, who will tell me that I'm actually rehabilitating the orthodoxy and all the inequalities that come with it. Later on, I hope to show that even if I do not verse into nihilism, my heuristic exercise has a huge critical power and potential. So these are the two preliminary caveats I wanted to formulate, of course, with a view to already preempting some of the criticism. But this is part of setting the stage. I now turn to my second set of observation devoted to my notion of belief system. What do I mean by that? And I appreciate at this stage it still is very cryptic. Well, in my view, a belief system refers to the dominant interrelated attitude within a community as to what is regarded as tolerable, true, acceptable, and which determine how to make sense of the world. So in other words, in a belief system, as I understand it, truth, meaning, or just the sense of the world are constructed by reference to some pre-existing validators, which are themselves unproved, unjudged, and unevidenced. So these validators in the belief system are what the believers turn to when they want to create meaning, when they want to create truth, when they want to make a claim. These validators are unquestioned, unjudged, unevidenced, and therefore they are ontological because they explain themselves. And that's the linchpin of a belief system, is that the validators to which the believers turn explain themselves, so they don't need to be demonstrated. Well, the claim that law is a belief system is not at all groundbreaking. This is something that has permeated legal realism at the beginning of the 20th century. And you have found this later in critical legal studies. And the same holds for international legal scholarship. It's very common for international lawyers to depict international law as a belief system. It is a dominant claim in critical thinking. But James Crawford said that when he received the Hudson Medal at the American Society of International Law a few years ago, and just even a few weeks ago, Professor Nolte mentioned that international law had the characteristics of a belief system. So as such, it is not a groundbreaking and heretic claim. However, in my view, this contention that international law is a belief system has never been fully articulated. And it is my ambition tonight to explain and spell out how I articulate that claim and why I see international law as a belief system. And I hope I will show you that international law is a belief system because it rests on these fundamental doctrines, sources, responsibility, interpretation, personality, and so on, which are held as ontological actualities that are unjudged, undemonstrated, and to which we constantly turn for guidance when we make legal claims and build legal discourses. The fact, and this is possible because, as I will explain, fundamental doctrines explain themselves. And again, this is the mark of a belief system. I think a few additional conceptual observations are necessary to introduce my understanding of fundamental doctrines of international law. As I've said, the notion refers to these key sets of modes of legal reasoning, like sources, the doctrine of sources, interpretation, responsibility, personality, territory, succession, and so on. So these are these clusters of mode of legal reasoning which we must rely on and deploy when we make legal claims about the rights and duties of legal persons in the international legal order, when we make legal claims about the consequences of a breach of the rules of international law, when we make legal claims about existing rules, when we make legal claims about the configuration of the world and the delimitation of territories, or when we make legal claims about international institutional or procedural arrangements. These fundamental doctrines are the seeds of our legal arguments and of our legal discourses. Some colleagues have referred to these fundamental doctrines as protocols of reasoning, argumentative codes of conduct. Of course, this is very famous as clusters of topois, rules of legal arts, or paths for arguments. For the sake of convenience and for didactic purposes, I do refer to fundamental doctrines of international law. And they are therefore organized clusters of modes of legal reasoning. And this is what we turn to when we want to make a legal claim and build a legal discourse. They determine the world of the possible and the impossible. They determine which combination of modes of legal argumentations are possible and those which are not possible. They come with a high degree of axiomization, systematization. They systematized modes of legal reasoning. They accept certain sequences, certain combinations, and not others. Some of these fundamental doctrines are highly systematized, and I think a good example thereof is doctrine of state responsibility. Some others are less systematized, or they are growing even less systematized these days, and that's the doctrine of customary international law, for instance. Well, these are my notions, and this is what I understand by belief system on the one hand, fundamental doctrines on the other. The key idea behind the notion of belief system is this idea that the validators that determine the truth or meaning are self-explained. They explain themselves. And this is the case of the fundamental doctrines of international law, which are these clusters of modes of legal reasoning we turn to when we want to make a legal claim. So far, I've just set the stage for my claim, and this has been, I believe, rather elementary. And I would like now to turn to my third set of observations, and I believe this is where things are getting serious. What does it take for international law to be a belief system? In other words, how does the belief system of international law work? Well, my contention is that it takes three conditions to be fulfilled. And it's because international law fulfills these three conditions that we can speak about an international belief system. These three conditions are, first, what I call ruleness. The fact that all our fundamental doctrines are meant to be set of rules. The rules on responsibility, the rules on sources. The second condition, and I will elaborate on each of them, the second condition is what I call the genealogical artificiality behind each fundamental doctrine. The fact that we need to create a genealogy for all our fundamental doctrines. That's the second condition, the genealogical artificiality. And the third, and probably most central condition, is self-referentiality. And self-referentiality is made possible because of the two other conditions. They are cumulative. Once these three conditions are met, the belief system is in place and international law can work as a belief system. So these are the three conditions that allow the fundamental doctrines of international law to play the role of these unproved, unevidenced, unjudged validators to which we turn to make legal claims. So the first condition, ruleness, the idea that fundamental doctrines boil down to rules. Well, that's a representation of our fundamental doctrines, which is, I believe, dominant and uncontested. It suffices to open a judgment of the ICJ or a report of the ILC to see that international lawyers speak about these clusters of modes of legal reasoning in terms of rules. And the rules on interpretations, the rules on responsibility, the rules on sources. We refer to the rules on the determination and the identification of custom, which is allegedly derived from 38. The rules on jus cogens, the rules on statehood. So that's just the common representation of our fundamental doctrines. And that's a prerequisite for the belief system. And I do believe I might be the only one in this world who has challenged this ruleness of fundamental doctrines. I do think it is not as self-evident as that. But the point is precisely that we need this ruleness for the belief system to operate. So that's the first condition. All central doctrines are sets of rules, just like all the other rules. Second condition, and I appreciate that this is slightly more arcane and abstract, but I'll give you a few concrete examples. This idea of a genealogical artificiality. Behind each doctrine, we need to create a genealogy. Because there are rules. There are rules because of this dominant ruleness. Hence, they need a repository. As rules, they must have some kind of formal nest. They must have a formal container. Rules must have a formal container in our understanding of law. Well, this is why we need to create this artificial genealogy. We need to create a genealogical link between these fundamental doctrines and a formal instrument. We need to locate these rules that form the fundamental doctrines in a given international text, from which we can allegedly derive the fundamental doctrines and the modes of legal reasoning they put in place. I'm totally mindful that at this stage there must be a very severe headache in the room, but I'll come to a very concrete example. The point is that we have these rules on responsibility, rules on statehood, rules on interpretation. They must come from somewhere. We must give them a nest. So we must find a text somewhere that can accommodate them. And in doing so, we also build a history for fundamental doctrines. And we build a historical narratives whereby the rules on interpretations are derived from the Vienna Convention Law of Treaties, whereby the law on statehood is derived from Montevideo Convention, whereby the doctrine of customary international law is derived from Article 38. We have to create a link between the two-element doctrine and Article 38. We have to create a link between the rules on interpretation and Article 31-32. This is the genealogical link, which is necessary for the belief system to be in place. I'm saying that this genealogical link is artificial because it is the product of the belief system. It is imaginative. And here I come to two very elementary examples, drawing on two doctrines you're all very familiar with. Statehood. Well, statehood, as we are told, or at least the modes of legal reasoning on statehood, are derived from a few of these international instruments, the 1933 Montevideo Convention on the Rights and Duties of States, possibly supplemented by a few opinions of the Badinter Commission. That's the law on statehood. Well, interestingly, the 1933 Convention on the Rights and Duties of States, adopted in Montevideo, was not about states. It was about non-intervention. And actually, it's only once the US agreed to the position of Latin American states on non-intervention that the convention was adopted. Also, the Montevideo Convention was not meant to codify universal international law. It was meant to codify the law of the Americas. So it was not meant to state any universal rules, any universal modes of legal reasoning regarding the state and regarding the determination of who qualifies as a state. And surprisingly, in the 30s, 40s, scholars never referred to the Montevideo Convention to back up and underpin and support their understanding of the state. Because actually, until the mid-20th centuries, nobody cared about having a universal definition of the state. Authors would define the state in their treaties for didactic purposes. And very often they will just refer to Jelinek. But at the time, people felt it was not necessary to have rules on the state and a law of statehood. The law of statehood is an invention of the second half of the 20th century. Now, it's only in the 50s and 60s that we witnessed scholars, the drive and the quest of scholars for a law of statehood and for a formalization of our modes of legal reasoning on how we determine who is a state and who is not. And here, what you witness in the scholarship in the 50s and 60s is that people started to look for a formal nest for their rules on statehood, for their modes of legal reasoning on statehood. And the only one they could find was this regional convention, which originally was not meant to universalize anything. So they just picked the convention and they built this narrative whereby the modes of legal reasoning on statehood are derived from the 1933 Montevideo Convention on the Right of States. They've built a genealogy for the modes of legal reasoning on statehood. And ever since, this is just the way we speak about state. And there have been some supplementary instruments, like the opinions of the Badinter Commission. But that's what I mean by the genealogical artificiality. I'll give you another example. And after that, you'll be very angry at me. Custom. I've already alluded to that. And some people in the room know my argument on this. Well, we are said by very esteemed colleagues that according to Article 38, we need to ascertain two elements to identify custom. That's what you find in all textbooks, very respectable textbooks. That's what you find in the LC reports. And they all say, well, it all comes from 38, but 38 is very poorly drafted. Because actually 38 does not systematically distinguish between opinion juris and practice. Again, here, what we witness is an example of a genealogy which has been built by a community. 38 is not poorly drafted. 38 reflects its time. That is a time where we didn't distinguish systematically and rigorously between opinion juris and practice. It's not poorly drafted. You have this wonderful study of 150 pages in the Revue Générale by Professor Peter Hagenmacher that shows that actually at the time we were much closer to a one-element doctrine of custom. The two-element doctrine of custom international law is actually a product of the PCIJ. It is the PCIJ which in the 20s came to distinguish between opinion juris and practice. And still, we tell ourselves and we tell our students that the two elements doctrine comes from Article 38. Again, we've built a genealogy. We've built a genealogy between the two-element doctrine and one of these authoritative texts we can, maybe the only one we could find, that is Article 38. So this is the same process as the one we've witnessed with the doctrine of statehood. And you could do the same exercise for all the fundamental doctrines. So that's what I mean by is building a genealogical link between modes of legal reasoning put in place by a fundamental doctrine and an authoritative text. Or which instruments qualify as the formal repositories of our fundamental doctrines? I mean, which are the candidates? Well, it's not accidental that we've usually turned to instruments with some formal virtues. Formally binding instruments, treaties, instruments adopted by bodies entrusted with codifying power, possibly drawing on customary international law, as well as judicial pronouncement. Judicial pronouncement have sometimes served as the repository of our doctrines. Or the most common repositories for fundamental doctrines are obviously the Statute of the ICJ, the Montevideo Convention, the Article on State Responsibility, the Vienna Convention on Law of Treaties. But there are also maybe a few judicial pronouncements and judgments of the court, of the permanent court and of the current court, which have played that function of being the repository of our modes of legal reasoning on these fundamental doctrines. I mean, I do think, for instance, that the reparation for injuries advisory opinion is one of these formal repositories where we, around which we've built a genealogy with some of the fundamental rules on the law of international organizations. It happens that the formal repository where we have that accommodate our fundamental doctrine are not tangible or very formal. It may have happened in the history of these fundamental doctrines that at a certain point in history we relied on a scholarly article. before the codification of the law of state responsibility and the first judicial pronouncement, well, Anzilotti's articles in the Revue Générale, again, may have served as this formal repository for our doctrine of responsibility. Sometimes even diplomatic correspondence may have served as the repository of modes of legal reasoning, for instance, on self-defense, if you take the Caroline incident. But this has always been transitional until a more formal text and formal instrument has been found. So that's the second condition for the belief system, a genealogical link between the doctrine and an authoritative international instrument from which we can allegedly derive the doctrine. So this genealogy which we built, well, it bears several effects, some of which I have mentioned. The first one is it allows this image of a derivation of the doctrine of statehood from Montevideo. So it's the idea of derivation. The fundamental doctrines are derivatives. The second is that it builds a certain historical narratives for all of fundamental doctrines. The two-element doctrine of customary international law was made in The Hague, in a rainy month of July in 1920. So it brings about a historical narratives about where our fundamental doctrines come from. And last but not least, this universal, this genealogical link allows us to give universality and permanence to our fundamental doctrine. Universality in the sense it allows us to sell them as universal modes of legal reasoning. Everybody ought to argue custom according to the two elements allegedly derived from 38. It also brings about permanence in the sense that it gives assurances to everyone here that the way we speak about custom, the way we speak about responsibility today, will still be the same tomorrow, and meaning that the legal arguments we make today will still be intelligible tomorrow, because the fundamental doctrine will not change, because it has been given this formal authoritative nest. So these are the two first conditions. Ruleness, genealogy, or genealogical artificiality. We come here to a third condition, which is the key, the cornerstone of the belief system, and which is made possible by the two first conditions, and that's self-referentiality. Once self-referentiality is in place, the whole belief system is at work. So I turn now to the last condition which allows fundamental doctrines, responsibility, sources, interpretation, to be unexplained and to be unjudged, to be these unjudged validators to which we all turn to make legal claims. Well, we have rules on responsibility, rules on interpretation, rules on statehood, and they are derived from some major formal instrument. Well, then everything falls into place, because the making of these doctrines becomes a question of the making of the international instrument. The interpretation of these fundamental doctrines becomes a question of the interpretation of the authoritative instrument from which the doctrine is derived. So in other words, once fundamental doctrines are equated to rules derived from an international instrument, the making of their modes of legal reasoning become a question of sources of international law. And their functioning becomes a question of the doctrine of interpretation. So the doctrine of sources, as a result of this ruleness and genealogical artificiality, the doctrine of sources comes to explain the formation of the fundamental doctrine, and that is how they are made, while the doctrine of interpretation comes to explain the functioning of those fundamental doctrine, that is, how they should be applied and interpreted. So the result of this is that through sources of interpretation, the fundamental doctrines explain themselves. They can invent their own origin. The origin is explained by the doctrine of sources. They can dictate their own functioning. The functioning of all the fundamental doctrines is reduced to a question of interpretation. So fundamental doctrines at the end of the day are made like other rules. They are interpreted like other rules. And so taken together, the fundamental doctrines explain themselves. They do not need to be demonstrated or judged. They become ontological validators for all our legal discourses. And these are the three conditions: ruleness, genealogical artificiality that allows the rules to be derived from a fundamental or authoritative instrument, which in turn allows self-referentiality. The making of the fundamental doctrines is reduced to a question of sources, including the making of the sources themselves. The interpretation or the functioning of fundamental doctrine is reduced to a question of interpretation, regulated by the doctrine of interpretation. So taken together, all these doctrines explain their own making and functioning. The belief system is in place, but there is still one element missing in the puzzle, which is why do we then turn to these fundamental doctrines? Why do we make these doctrines the validators of all our legal reasonings and discourses if they are explained just by themselves? Well, that's the magic of the belief system, is that it creates an experienced sense of constraint. Now, international lawyers come to experience a sense of constraints towards this doctrine, and that's it's the magic of self-referentiality. International lawyers, by virtue of this belief system in place, experience that those instruments dictate the way they should argue about custom, about responsibility, about statehood. Without any irony, they hear these fundamental texts speak to them and enunciate modes of legal arguments about custom, statehood, interpretation. So they come to think as these fundamental doctrines as these validators that call for no empirical or rational demonstration. They come to be taken for granted thanks to their self-referentiality. So they experience a sense of constraint towards these doctrines, and they don't feel under any pressure by any evidentiary demand from the external world. There's just enough. They have justified themselves, and that's more than enough. So then the fundamental doctrines, by virtue of their ruleness, genealogical artificiality, and self-referentiality, have become these validators which we find in all belief system, and which call for no evidence empirically and rationally. Well, this is how the belief system works. And you might recognize yourself, at least I recognize myself, that's how it works. But this is not a bad thing. This is not a bad thing. Once again, I want to say that I'm making this claim without repudiating the way we construct legal argument. Or there may be an objection at this stage, and I'm going to move to my last part, but there may be an objection at this stage pertaining to our possible awareness of all this. I'm looking at Georg because that's the question I expected, so I'm trying to preempt it. You may say, well, we're aware of this. So how can you still speak of a belief system? Maybe we do this in bad faith. Well, first of all, I don't think full awareness is possible because it is inherent in a belief system to obfuscate itself. So I don't think we can be fully aware. But even if we are aware, I do think that we will never dare to say out loud that we feel a sense of constraint. We would never dare to say that we do this out of dogmatism. We will never dare to say that we hear these texts speak to us. No, we are too afraid of the charges of arbitrariness or naive objectivism. So I do think that even the most aware of us will still continue to believe. And so I don't think the awareness of some member of the community of international lawyers constitutes an obstacle. One last remark about this, before I turn to my last part, which will be much briefer. But this sense of constraints we feel, we experience towards fundamental doctrines, does not necessarily come naturally. I mean, we have ruleness, we have the genealogical artificiality, we have self-referentiality, but still, all this will actually take shape and fall into place thanks to training. When we are trained as an international lawyers, and we're taught all these doctrines, we are actually taught to experience that sense of constraint. So the training we give to students, and the training we give to ourselves by reading scholarship, is actually very instrumental in our feeling of constraint towards these fundamental doctrines. And I do think that this feeling of constraints also come from the memory of the constraint felt by others. Oh, Brownlee, Crawford, the ICJ, they all felt constrained. So we should be constrained as well. And I think it shows also the function of another function of textbooks, which is to perpetuate the experience of a sense of constraints towards the fundamental doctrines. So 3 conditions for the realization of the belief system: ruleness, genealogical artificiality, and self-referentiality. The belief system is in place. I would like now to turn to the 4th and last observations I wanted to formulate tonight. So by now you must have a terrible headache, and you may wonder what the added value of all this is. A few people left the room, by the way, already, and I can't blame them. Well, this is not meant only as... So this is a heuristic exercise, I've said. It's not meant to make a grand claim about what international law is and is not. It's probably instructive, reflexive. It has made you think tonight. But I do think there is a critical potential here as well. It's not only a reflexive exercise. I think that once we are aware of the belief system, we can suspend it. And that's the critical potential of my claim. We can stop for a minute between the lecture hall where we have to teach the fundamental doctrines and UN bodies where we have to sit. We can stop in between in the corridor and suspend the belief system. Well, I think my main claim actually boils down to an invitation to suspend the belief system for a while. Not permanently, but temporarily. And I do think there are 2 critical gains, 2 critical benefits associated with the suspension of such a belief system. And I think that's the value of this whole exercise. The first one is that it allows a contestation of all these linear historical accounts we've built around these fundamental doctrines. We had Montevideo, and then we witnessed the growth of very sophisticated modes of legal reasoning about how the state is formed in the international arena. We had Article 38, which put in place a very sophisticated way to articulate our legal claims on custom. We had the Article on State Responsibility that put in place. So it's all this, we can revisit all these linear historical accounts that start with the adoption of the text, the authoritative text, which accommodates the fundamental doctrines. So that's one gain. So historiographical gain. Let's challenge a little bit these linear narratives, historical narratives we've built around our doctrines. But there is another gain, maybe more important, but also more dangerous. That's the gain of suspending the belief system for a while. This is what I call the unlearning. Once you manage to step out the belief system, you can, for a moment, unlearn all what you've been taught for 1, 2, 3, 4, 5, 6 decades. Unlearning. I mean, I borrowed this from, it's not my word, it's from Bourdieu. Or it allows you to do away with what is called by French sociologists the miscognition. The belief system miscognizes you into thinking that the two-element doctrine of custom comes from 38. Well, let's unlearn that for a minute. Just for a minute, because the moment you step into the great hall of justice, you'll have to speak the language of the two elements, referring to 38. And so the value is to, for a moment, to suspend and to unlearn. Or there are two specific things which I think we could unlearn if we suspend the belief system. Well, the first one is we can unlearn source-based self-referentiality, the explanation of the making of the fundamental doctrines through the sources. So let's stop thinking about the making of the fundamental doctrines in terms of sources. Let's stop construing the making of responsibility of the sources doctrine, of custom doctrine as a law-making process. Let's just stop this. Let's just see that these fundamental doctrines are actually the result of a wide variety of very distinct intervention by a wide variety of actors. Actors which have intervened to impose some modes of legal reasoning, some other actors which have imposed the way these modes of legal reasoning are systematized. Other actors have stepped in and have packaged the whole thing as a doctrine of responsibility. Others have picked the formal repository in which this doctrine has been nested. It's just the making of these fundamental doctrine is not a law-making process. It is just the accumulation of a variety of intervention. Custom was imposed upon us by the PCIJ. Breach and attribution, when we articulate legal claims on responsibility, was imposed upon us by Italian scholars. The way we formulate interpretive claims about interpretation was imposed upon us by virtue of a conspiracy between the Institute and the International Law Commission. It's not a law-making process. So that's what I mean by unlearning source-based self-referentiality. But don't get me wrong, it's not meant to be subversive. It's not because we develop some awareness for these various interventions that we need to reject the doctrine. Not at all. It's just, again, getting a better understanding of where the way we speak comes from. I think it just allows us to have a better understanding of our own modes of legal reasoning and the way we speak the language of international law. So in unlearning sources-based self-referentiality, you actually reverse completely the way we look at the making of fundamental doctrines like sources, custom, responsibility, and so on. It's no longer a top-down process whereby you derive the modes of legal reasoning from an instrument. No, it's a bottom-up process where some modes of legal reasoning have been designed, systematized, packaged, and then anchored into an international instrument. So it's no longer a question of lawmaking, it's a question of inventing tradition. So that's what it means to unlearn. Or you also need to unlearn thinking of these doctrines in terms of interpretation. The functioning of these doctrines is also, and don't worry, I just need 2 more minutes to wrap up. We also need to unlearn interpretation when we think about the fundamental doctrines. there are also a wide variety of intervention in the functioning of these doctrines. We may later on, after the doctrine is in place, seek to adjust it. For instance, take the doctrine of self-defense. You may wish to fill some gaps or clarify things, take reservations. You may wish to try to salvage what is not working, take custom. And so you have all kinds of interventions after the doctrine has been put in place. It's not a matter of intervention. It's not a matter of interpretation. It's a matter of intervention by a variety of actors, which may be different from those who created the doctrine and put it in place. Oh, don't get me wrong. I'm not saying that interpretation is not relevant. All these interventions are interpretive in nature. The only thing is the functioning of this doctrine is not governed by the doctrine of interpretation, or should not be necessarily governed by doctrine of interpretation. And above all, the interpretation of this doctrine is not an interpretation of the fundamental authoritative texts where they are nested. No, what you interpret when you intervene to adjust the doctrine is not the text itself. And I think that's what the suspension of the belief system teaches you. And I think in doing that, and I will conclude in a minute, it makes you more powerful reformers. It makes you more aware of how you can intervene in the making, remaking, unmaking of this fundamental doctrine. Well, obviously I've spoken enough, and it may be time to let you vent your anger or frustration. So I will conclude briefly. So I've projected an image of international law as a belief system, and I've said that by virtue of the idea of ruleness, a genealogical artificiality, and self-referentiality, international lawyers come to feel a sense of constraints towards these fundamental doctrines, and they naturally turn to these doctrines to determine the truth in international legal discourses. And this is possible because these fundamental doctrines explain themselves. They explain their own origin. They explain their functioning. Well, this is a heuristic exercise. The purpose was certainly reflexive. There is also this suspension of the belief system, which I believe may help us take a step back from some of these very ingrained patterns of legal thought. I appreciate, and I must end with this, that heuristics or heuristic exercises are not benign. They must be wielded with care. And it's not only about self-reflection. The consequences of what I've been saying tonight may be devastating, but they can be also very different. What I've been saying tonight can either rehabilitate the intolerable, but it can also encourage heresy and the repudiation of international law as a whole. Or you may think I'm a coward, but I don't want to be held. I don't want to be held hostage of the consequences of this idea of a belief system. So I'm not going to intervene and tell you what you should do with this idea of a belief system. I do believe that it's up to international lawyers engaging with this idea of a belief system and possibly suspending this belief system to decide what they do with it. This is some sort of consequentialist agnosticism, which will be held against me. And I know exactly who in the room is going to hold this against me. But somehow it doesn't make me uncomfortable. I mean, I've not invented anything, but still nobody blames Marie Curie for allowing both the cure of cancer and the destruction of humanity. Still, there is one consequence of all what I've said, which I want to prevent, which I want to warn you against, and which I forcefully oppose. So I'm not completely agnostic. I don't think that what I've said tonight should lead to apostasy. That is, a renunciation of all the beliefs we have towards our fundamental doctrines and modes of legal reasoning. I think apostasy is a no-go, it's not an option. For two reasons. First, we should not forget that these fundamental doctrines and the system, the belief system built around them, is what makes communication between international lawyers possible. It is what, and even more fundamentally, the belief system is what makes international legal discourses possible. So we shouldn't get rid of this. That's the first reason why I reject apostasy and the end of the belief system. The second reason is that even if we are unhappy with the belief system, even if we are unhappy with the fundamental doctrines and we want to fix them, we want to fix the injustice in the distributive justice problems that come with it, we want to fix the inequalities, I still believe that repudiating the belief system is not an option. It leads us nowhere. I think we should remember that even reform and revolution take place within a tradition. The revolutionary or the reformer are usually the most situated members of a community. So in that sense, the apostate international lawyers has no chance to reform or change anything. And in that sense, ladies and gentlemen, and I will finish here, the belief system I've described tonight is both what makes us prisoners of the past and reformers of the future. And whether we like it or not, I think we're all bound to be believers. And I thank you for your attention.